Judicial Department. Hear ye, hear ye, hear ye. Persons having business in Judicial Court will draw near, give their attendance, and they shall be heard.
Okay, good morning. Have a seat, everybody. Okay, our first case for argument, People versus Lovell, and they're both video. Okay, no problem. Not a problem. I have you down here. Good morning, counselors.
Good morning. May it please the court. Brad King for Matthew Lovell. I'd like to start with our claim of ineffective assistance of counsel. As in this court's recent Stewart decision, which just my luck, none of the justices today were on.
But we read.
Fair. We assert it was error for defense counsel to fail to object to the trial court's unlawful peremptory challenge order system. Contrary to the language of 270-15, defense counsel can't acquiesce to an unlawful procedure. It was not a legitimate strategy. And here, as in Stewart, we have ineffective for the peremptory challenge issue plus. And that most flagrant plus was the failure to object to juror number 80, who eventually became juror number 3. That juror said that she felt uncomfortable about the subject matter of the case. She said it was difficult to decide someone's fate. And most importantly, for Mr. Lovell, is she admitted she valued law enforcement's testimony over that of a layperson.
In this particular case, how important was the law enforcement testimony as opposed to the witnesses that were all there and all testified?
Sure. The law enforcement did testify in the case, Your Honor, though, still at the same time. And it wasn't at the time of voir dire, defense counsel had no idea how the people were going to put on their case. And
right, but the defense counsel did know that the officers responded well after the events occurred. It's not like, there's body camera footage of an event in progress or something like that, and that everything really turned on the witnesses.
At the same time, I would point the court to the fact that these officers were the first people to observe these 3 women, and that the officers' observations were still extremely important. And when someone is pro-law enforcement, I think there's not a far jump to say that they're going to be pro-prosecution, and that failing to exercise a peremptory challenge on that particular juror, when combined with the peremptory challenge issue and the other aggregate errors that I discussed in the brief, certainly follow the Stewart case in ineffective plus for this court to order a new trial.
What's your response to the people's argument? Because I didn't really see it addressed in the reply brief that 5 out of the 6 jurors that where defense counsel had to go first, improperly had to go first for those peremptory challenges, those ended up being accepted by the people anyway. So really this is of no moment.
I don't think that it can ever be of no moment simply because the way that the selection ended up. It would be impossible to predict how it could have gone the other way if the voir dire would have gone the correct way. How it would have played out. It's Monday morning quarterbacking, in my opinion. Once the judge improperly started the voir dire process by asking defense counsel to go first, and defense counsel did not object, at that moment, that's when ineffective assistance of counsel occurred.
Okay, now I noticed that your client's already out.
He is, Your Honor.
All right, so I guess I'm just wondering about the mechanics of how it would even work and whether or not he could benefit by any of this.
Well, I think that's a very good question. And I think he would like to be able to potentially go back and force the people to try him again, because he thinks that he maintains his innocence and he does not obviously want to register as a sex offender and have a sex offense on his record. So I think that there's certainly mechanically, it is a little bit interesting because he is out and he certainly puts himself at some jeopardy, not discounting the possibility of vindictiveness or something of that nature. But for him, this is a worthwhile endeavor.
Thank you, counsel.
Unless there are questions, I wanted to apologize to the court for missing the letter in regard to the Alfred plea point. I don't think the content of the letter, though, really changes my argument that the trial court misapprehended what his issue with him taking an Alfred plea was that he didn't remember. But an Alfred plea that he didn't remember is not important to an Alfred plea. His recollection of the incident is just not important. It's just that it's a voluntary and rational choice, and the record reflects strong evidence of actual guilt. And I'd ask the court to take a strong look at that issue, as I know it will.
Well, didn't his new counsel indicate to him that he wanted to go to trial anyways?
The
So
new counsel,
they didn't want the Alfred plea?
new counsel certainly did, Your Honor. I think that we have to look at that moment with prior defense counsel. The only thing stopping this case from what would have been a probationary sentence was the trial court's refusal to accept an Alfred plea for reasons that are not based really on the law, in my opinion.
Thank you.
Counsel?
Thank you, Your Honor. Amy Hollenbeck on behalf of the people. I would also like to apologize for missing that letter on the Alfred plea. We didn't notice it. We were in the record, the reference to it. I would, however, submit that it just supports our argument that the court properly exercises discretion in regard to the Alfred plea based upon what was going on at the time with the defendant maintaining his innocence, but at the same time saying he didn't remember, which was the prosecutor's basis for being willing to accept the plea in the first place, the Alfred plea, and then exercising his right to trial. In regard to the ineffective assistance of counsel argument, we would certainly agree that it was error not to object to the selection process method utilized by the court. I did not reference the court to the Stewart case really because.
Well, Counselor, how is this not similar to Stewart? How do you distinguish Stewart from this?
And for exactly the reason that I would submit, Your Honor, that there was no other. The Stewart decision, my understanding of the court's decision, it was not that it was based upon that single error, but that it was based on alleged other ineffectiveness on the part of defense counsel in that case. And disrespectfully, we disagree with that, but we don't see that ineffectiveness or the level of that ineffectiveness in this case. The only real argument here, as pointed out, is juror number 80, and I would submit that that is not an example of ineffectiveness. Juror number 80 during jury selection process, as I noted in my brief, referenced that she, when talking about the incident, called it what allegedly happened and confirmed that if she were a defendant, victim, a witness, she would want a jury to hear her case. I think those statements by her indicated her ability to be a fair and impartial juror, and tactically it was not unreasonable for the defense not to exercise a peremptory during the jury selection process. Also, I note that she was a really early juror. I think she was number 3 to be seated, if I'm remembering correctly, which there's just no way, again, Monday morning quarterbacking, there's no way to get into the mind of the defense counsel as he's doing that, but it's not unreasonable for him to keep someone on a jury who uses words like allegedly happened as indicative of fairness when he's got a whole panel in front of him to choose from and doesn't know exactly who's coming up next. So I would submit, and there were none of the other items that were of any significance. So that, to me, the difference between Stewart in this case is the alleged level of ineffectiveness is very different. And really, if there's an error in this case, it's a single error. in the method of the jury selection process, which, as is pointed out, really resulted in no prejudice to the defendant. If we say every time this error occurs, and we would like it not to occur anymore, but if we say every time it occurs and isn't objected to, it requires a new trial, then we're turning it into a mode of proceedings error. And if it's already been determined many times this is not a mode of proceedings error, and therefore, in order to justify the need for a new trial, there needs to be some prejudice.
Well, Stewart was more of an interest of justice decision, correct?
Yes, exactly, Your Honor.
The culmination of all the perceived errors amounted to an interest of justice contention by the court.
Exactly, Your Honor, and I would submit. I'm
So
sorry.
you're really not, you're not making a mode of, you're not making that mode of proceedings are necessary then if it's an interest of justice situation.
No, Your Honor, but my argument would be that it is not an interest of justice because there was no unfairness here. The result was.
Well, then you're talking about the unfairness or ineffectiveness of counsel. During those Alfred arguments, the defense counsel revealed confidential statements of the defendant, making him a potential witness. Isn't that right? Didn't he say that the defendant revealed, "I've been here for 16 months. I wish I could take it back what I did to her."
Yes.
He
Your
made
Honor,
those comments to the court.
Right, that did happen. It was a different counsel at trial, but that did happen during the Alfred plea discussion, exactly as the court has indicated. But one thing we don't know for sure.
Oh, doesn't it go that
the defendant gave him permission to do that. The lower court saw it as revealing confidentiality, but we don't know what the conversations were because there's been no 440. We don't know what was going on exactly, and that was during the Alfred plea discussions. Didn't I would submit have any effect on the outcome of the trial in this case. I mean, I don't know how it could be related to that, something that was said to the court. And additionally, when the defendant did testify, he did not deny that he did certain things and said certain things during this that would be consistent with that statement.
Okay, thank you, counsel.
Thank you, Your Honor.
People versus Iqbal?
Thank you.
Hold on one second. Counsel's getting set up there.
May it please the court, the people, Mr. Iqbal, James Eckert of counsel for the Monroe County Public Defender's Office. The weight of the evidence point is very important to Mr. Iqbal. I'll be happy to answer any questions with regard to the facts. I think that point is relevant to the legal points as well, as I submit that the jury found reasonable doubt where the proof was only the complainant's testimony. The first legal point, point two, is to confront and cross-examine the complainant, and the defense attempted to question her with regard to details, with regard to the fact, which is the way you determine, or the jury determines whether or not they're going to believe the witness. Anyone can just recite what the complaint is. It's being able to provide telling details that makes it convincing. And I think that the right to ask questions about both her job interview and the circumstances surrounding the photo of the shoulder was preserved by defense counsel asking that question. I think in cross-examining the defense witness, the sister-in-law of Mr. Iqbal, the prosecutor committed misconduct by asking that witness to characterize the complainant as a terrorist. Now, the complaint was sustained, but there was a specific request for a curative instruction, which the court declined, and therefore there was no explanation to the jury. I think the question was inexcusable. It's very harmful that there's no proper purpose for such a question, and the Court of Appeals has made it clear that arguments of counsel cannot substitute for an instruction from the court. So I don't think that defense counsel's objection constitutes sufficient notice to the jury, and we needed a curative instruction to ensure Mr. Iqbal's right to a fair trial.
I'm interested in you addressing, I think it's your last point with regard to the police officer's testimony.
Yes, Your Honor. The police officer was permitted over objection to testify to having taken photographs of 2 prior strangulation complainants and saying in those cases he saw no injury. First of all, it's unclear whether those people were actually victims of any crime at all. And it's irrelevant, as defense counsel objected, saying it has nothing to do with this. It's highly prejudicial because the implication is that a strangulation claim doesn't produce physical injuries that are visible later on, and therefore that, as the people concede,
There's no evidence at all on the record with whether or not those prior instances, whether it was 1 or 2 instances where he photographed strangulation, alleged strangulation situation, whether or not there was ever any charges or any convictions with respect to that.
Correct. No detail, nothing as to how long ago it was or anything to indicate that you would anticipate based on that, which the jury was invited to conclude that the absence of physical injury visible later on was perfectly consistent with a strangulation claim.
Was the defendant acquitted of a number of charges as well?
Absolutely. Where the complainant's testimony stood alone as to menacing, for example, he was acquitted. As to the attempted assault 1, he was acquitted. As to attempted assault 2, he was acquitted. As only attempted assault 3, which had some physical evidence associated with the damage to the clothing.
So here would be the same situation where we have just the witness testifying with respect to the alleged strangulation, but you supplement, the prosecution attempted to supplement that with the testimony of the officer with respect to, well, there were no signs of bruising in those other instances.
Exactly. And instead of the court preventing the testimony from being introduced, the court placed its own stamp on it by eliciting much of the proof on its own. As to prosecutorial misconduct and summation, I submit that if it's unpreserved, I would ask the court to review it in the interest of justice or as ineffective assistance of counsel, where even though counsel is generally not ineffective, it can be ineffective to fail to object under those circumstances. Thank you very much.
Thank you.
Good morning, Your Honors. Ryan Ash for the people. If you have any specific questions, such as to point 5,
Yeah,
you have to address them.
we're pretty interested in that.
Right. So it's the people's position that this case, that line of questioning, the court's interjections.
How relevant is that line of question?
The line of questioning is relevant to undercut a potential defense, meaning you shouldn't believe her at all. There's no injury. And that was going to quite obviously be a line of defense.
But we don't know in those other instances whether or not there was any in those instances where the officer testified he photographed these other, whether or not there was a charge or a conviction or anything with respect to that. So
Right.
wouldn't that be more relevant then? Oh yeah, in these other instances, there was no bruising, but here we had a conviction.
Right.
But here, that's not there. You're speculating, letting the jury speculate with respect to that.
I agree, but there's could be, like,
Could
I
be, yeah.
agree that there's a particular logical chain here, but the particular logical chain goes to undercutting the defense, and the defense could have cross-examined the same witness and say, well, let's talk about that. If we really want to get into the actual facts of that testimony, the defense could have cross-examined and elaborated. That's a proper scope of cross-examination if a witness has already testified as to something. And here, your question about the injury being relevant to the case, that element, or that crime didn't only have that element. The crime could have also been proven by stupor and loss of consciousness. So yes, there were acquittals on some counts, but that doesn't amount to a harmful error here where the element wasn't necessary to prove the charge at all. And her testimony was the only indication that she lost consciousness. Not only that there was like a lack of injury, but also she testified consistently about the set of facts. And I don't agree with the defense's characterization of the testimony as being inherently contradictory. This is a witness who's...
Well, didn't then the prosecutor in his closing accentuate the situation with respect to this, the fact that you also recall that he has been, this officer has been to other strangulations and investigated those, and he didn't find any injuries there either. So aren't you basically saying, well, because there's no injuries here, you know, there's a strangulation, we met all the elements and...
Well, no, because I don't think that, like, it doesn't make sense that there's no injury equals strangulation. That doesn't, I mean, in every case where there's not an injury, that would be a strangulation count. That doesn't make sense to me logically. What here it is they're undercutting the potential defense that, hey, look, there's no injuries. This obviously didn't happen. She's obviously making it up. Because fabrication was the essential defense strategy here.
And wasn't that successful in the other charges?
It was, I don't know, we don't, like, I don't know if it was successful in fabrication. The jury could have said, for any sort of reasons, that, you know, the menacing count or something like that wasn't full to the reasonable doubt. But but here, there's several counts that he was convicted on, and it's a single witness case because it's a single victim case that occurred in the privacy of the home. And as the defense counsel at trial stated, you either believe she was strangled or you don't. That's...
Counselor,
yes.
I want to follow up Justice Montour's question. It seems to me that the issue here is that the record is lacking any foundation for that testimony. You don't disagree.
Well, the foundation being his prior investigations. We didn't go into the...
There's a lot of assumptions, as you say, in order for that. There is no evidence in the record that indicates... well, you would agree with me, there's no foundation for the police officer's testimony as to the prior investigation.
Well, I wouldn't necessarily agree with that because he testified that he was involved in those investigations, and that's his foundation. It's on the defense to voir dire or object to that ground. And here, there were a couple partial objections, but the objections kind of changed style over time. And then I think everybody in my reading of the record, that's a cold record, I can only assume, but my reading of the record was that everybody is kind of frustrated that, like, this bell kind of keeps getting rang over and over. And the court interjects and says, let's clear this up and let's move on. And now the argument on appeal is that what the court did was incorrect. You know, not necessarily what the prosecutor did. The court is moving this testimony along that the prosecutor seems interested in. And this is one way for the court to say, yeah, that's enough. Let's get this testimony in. Let's get your question in a proper way so that we don't have to keep asking it 10 times. And I think that's not something that doesn't disadvantage the court. The standard here is whether or not the court acted, you know, assume the role of the prosecutor. And I don't think the actions, when you read it in context, I don't think that's what the court was doing.
I'd like to ask you about the America quote from the summation.
In summation?
Prosecutor's
Okay.
summation. So in your brief, when you're dealing with that topic, and you deal with it kind of briefly on page 15 of your brief, you cite to, you respond and you say, well, you know, that was responding to the defense counsel's opening about America, and you cite to page 15 of the transcript. So I read that. And in the opening, the very first thing the counsel says is, you know, ladies and gentlemen of the jury, this is the first line to the jury, we truly have the best criminal justice system in the world. And the people object immediately. And then defense counsel says, you're going to object to having the best criminal justice in the world? Which maybe got a chuckle. And the court overruled it and said, go ahead, start. Essentially, he said, continue your opening, go ahead with your opening, really start your opening, because it didn't really get out of the box. Next thing he says, because we don't operate under stereotypes. That's it.
Right.
And that's what he says. Then defense counsel in closing says, the prosecution rather, Ms. Biggers in closing says, defense counsel was right about one thing. This is America. We do have the American justice system. You cannot do this in America. You cannot strangle people. You cannot threaten to slit their throat. You cannot light them on fire. That was her line from summation. Isn't she implying that the defendant believed that he had a right, like a moral right, a cultural right to do these things? That's not the defense at all. As you mentioned, the defense is fabrication.
Yeah, I don't believe that. I think that it would be, Well, in some ways, Your Honor, I think it would be almost naive to assume that the jury isn't thinking that these cultural contexts are, like, they're in the courtroom. The aspects of Muslim culture come into the defense witnesses' testimony and, at length. And I think the prosecutor's argument here is this isn't about, in a way, I think it's almost the opposite. The prosecutor's argument is this isn't about culture. This is about the American justice system and what's illegal.
So in your mind, she would have had to throw in the phrase, not like in Pakistan, you can do all this stuff.
No, I don't
think
think
she would have had to throw that in.
No, I don't think that's,
To me, that's how it reads. That's the next line that she didn't say, but that's what she's saying.
I don't agree with that characterization, Your Honor. And I think that, although I personally, acknowledge that the tact that this prosecutor took sometimes can be a little combative. And my understanding is that's her personality and that's the way that she takes these cases. But, and we saw that in other, like in the cross-examination of the defense witness, she's willing to call people out. And in a case where this is about, it's an immigrant culture, it's two, I think both of them were immigrants from Pakistan, the jury has heard this over and over. And for her to say, this is about the American justice system, I don't think that's error at all, Your Honor. I think it's almost naive to assume that she wouldn't, that the prosecutor shouldn't acknowledge that there's, that's the stroke that we're going to examine these charges under. I don't agree that she should have just ignored the fact that that the Muslim culture was brought into the courtroom multiple times by the defense.
All right, but the only citation you give us is the citation from the opening.
Yeah,
where it seems like the defense is arguing the exact opposite. Please don't put stereotypes in your thinking, whereas here in
Right.
summation, sounds like she said, oh, folks, you can, and you should here.
Okay,
And that you would agree if she did, that would be a problem.
If the prosecutor, this is a hypothetical, I really don't believe this happened in the case, but if the prosecutor came in and on her summation and said, look, this is a case about stereotypes, well, then that would be a completely different case. I don't think that's what's going on. I think that the prosecutor was doing her best to dance around these topics, and in some ways, sometimes, as you can tell from my currently trying to handle this topic, it's hard to artfully dance around things when you don't want to say something. And it's almost like, don't think of the pink elephant. As soon as you say those words, people are thinking about it. And for the prosecutor to come in here and say, in America, this is the standard and we can't do this, and your argument is that we're not allowed to reference America when there's people here who haven't spent their whole lives in America, I think that's a little unfair to this prosecutor who might not be able to think quickly on the feet and pick the perfect term of art when she's trying to actually respond to what the defense is saying. And to your point that I only said it at one point in my brief, and maybe I don't know if you're implying that maybe I didn't get the citation particularly correct.
No,
But,
I'm not implying.
I do remember
I think you found the best site you could.
I do remember my strategy for this brief was to actually break down those comments and link back her references to, this comment relates to this comment by the defense. This comment is actually, it's not said in the same sort of verbiage, but it's actually addressing this comment by the defense. And I think that's clear from this, once again, cold record. That's what the prosecutor was trying to do. If you have any direct questions, I'd be happy to answer them,
I
but
think we're done.
otherwise
Thank
I'll
you.
rest. Thank you.
Okay, case number 218, People versus Vanderbilt. Okay, Mr. Schifrin is going to be appearing video. Okay, Mr. Schifrin, when you're ready. Oh,
Bye.
there you go. When you're ready, Mr. Schifrin.
Good morning, Your Honor. Brian Schifrin on behalf of Norman Vanderbilt. We urge first that the record does not establish only intelligent waiver by Mr. Vanderbilt of his right to an attorney, where the court failed to conduct the required searching inquiry to show that Mr. Vanderbilt understood consequences of proceeding pro se.
Okay, I'm going to just say, it appeared to me that the court, that it tried very hard to get that point across. I guess you're saying that they weren't successful.
No, respectfully, Your Honor, what the court did is half of what the court's required to do. The court clearly laid out in detail the disadvantages of proceeding pro se. However, more is required. In Sawyer, the court said there has to be a colloquy to show that the defendant understood that. The court asked only a couple of questions of Mr. Vanderbilt, and he didn't get responsive answers. His first answer was, "I don't understand why I'm here." Then he twice said, "I don't wish to participate." Those are not answers showing the required understanding. The district attorney says, well, this is virtually verbatim. That's the language in the respondent's brief to the model colloquy on waiver of attorney. To the contrary, as detailed in our reply brief, the model colloquy requires 11 different times during the explanation of the risks of proceeding pro se for the court to say, ask the defendant, do you understand? That was not done here.
You list those 11 times on the page 4 of your reply brief, and it's helpful. The thing that you have here, and we have it a number of times, is the court asking a question, and the people point out that the court sort of started in this March 29th transcript, and that, I don't think that was the first time, but will you participate to the extent of answering my questions that will assure me that you're able to represent yourself? So there's sort of a question before you get to these 11. You get to this question, are you gonna listen to my questions and answer? And then the defendant responded as he had previously. I don't wish to participate. You lack jurisdiction over me. This court lacks jurisdiction over me. And had already said that a number of times before and then after that statement. I wonder if the 11 questions that you set out on page 4 of the reply brief, if those were asked, would you keep getting that same response? I'm not going to participate. You don't have jurisdiction over me. Just this sort of rote thing over and over again. You're suggesting that that may be the case, but the court has to do that. You've got to go through it, even though the person sort of made themselves clear as to their political beliefs. You have to go through it one by one, as you say on page 4.
Not necessarily there's a requirement, a legal constitutional requirement, statutory requirement to ask for 11, but what's required, particularly when you're dealing with someone who's a self-styled sovereign citizen who doesn't wish to participate, is to ensure the understanding. It's not enough. I'm laughing because I have grandchildren who I say things to, and I say them, I thought clearly, but they don't seem to understand, okay? There's a duty for the court to understand. Here, not only is this a sovereign citizen, so that I would argue an extra duty to make sure that this is a person who's able to participate and understand what's going on, but Mr. Vanderbilt twice prior to the court going through disadvantages, twice told the court, I have problems hearing. The court made no follow-up questions. The model colloquy, in part, requires the asking of these pedigree questions about physical and mental health. With respect to physical health, upon hearing the defendant has hearing issues, there should have been some inquiry to determine whether that would have impacted his ability to proceed as counsel, let alone as a defendant without additional services. And hearing that a defendant is a sovereign citizen who doesn't wish to participate, and then I cite the case law, I believe in pages 21 and 22 of the appellant's brief, provokes a duty to do inquiry to make sure the person is able to participate, that this belief system that the laws don't apply to him is not based on some mental disability. At one point during the trial, the defendant, Mr. Vanderbilt, says, does anybody here think this is insane? To which the court responds, I find you that way. That response suggests the court recognized there were problems with Mr. Vanderbilt. Mr. Vanderbilt, who never filed any motions despite there appearing to be a valid or meritorious 30-30 motion. Mr. Vanderbilt, who believed that he was arrested without probable cause, never sought a probable cause hearing, and was shocked at the end to find out you can't get a probable cause instruction when it was never litigated, wasn't someone who was competent to proceed. He never understood the consequences. When he finally understood all of this, too late after conviction, that's an attorney. If the court asked questions and sought an answer, getting an answer, I don't understand why I'm here, and then moving on shouldn't be held to be sufficient. More is required. And going back to the very beginning, Justice Dennis is absolutely correct. The court attempted, make a lengthy description of why it's risky to proceed without an attorney. And all that was required was for the court to make sure that Mr. Vanderbilt got that, and that the court failed to do that. This problem was compounded by the failure to take required measures, and this is point 2, with respect to the hearing issues that Mr. Vanderbilt mentioned throughout the proceedings. Judicial Law Section 390 requires a court to provide the language is appropriate aid or service to a defendant who is hard of hearing. That's a statute. The respondent's brief says that the statute only applies to people who are deaf. Well, the statute was amended in 2015 to include deaf or hard of hearing. The court took no measures, no point made an inquiry. Are you having problems hearing what's being said? Is there something that you need or we could do to assist? That wasn't done. We have a defendant sitting pro se, so he's both the defendant and his own attorney, and he's not necessarily hearing everything. That's a problem. And finally, with respect to point 3, there's 2 items I wish to mention. At the very beginning of sentencing, his attorney says there were numerous plea offers of a plea to 4 months. The district attorney did not dispute that. On the respondent's brief, the respondent's brief says, well, nothing in the record showing that. This court held in People v. Egan, when a person or party is silent, when you would expect them to say something, to dispute something, that's considered a tacit admission. The record here was what the defense counsel said. It was not disputed by the court or by the prosecutor. And finally, with respect to our claim that this court should consider the disparity between the sentence imposed and the sentence that was offered in the plea, we don't dispute that it wasn't preserved, but the Court of Appeals just last month in People v. Brisbane expressly held that, and citing numerous decisions of this court, that it is proper for the appellate division to consider, even when not preserved, the disparity between the promised offer and the sentence imposed after trial in determining whether this court wishes to exercise its interest of justice jurisdiction to reduce the sentence. We urge, as in the cases cited in both my brief and in the Brisbane decision by the Court of Appeals, this is an appropriate case for this court to reduce the sentence. Unless there are any other questions, I rest. Thank you.
Thank you, counsel.
Good morning, Your Honors. Michael Tantillo for the respondent. Regarding point 1 first, the right to counsel issue. There are 2 Court of Appeals cases that are directly on point, and I mean directly. They are People v. Providence and People v. Vivienzo, both of which held that where a court gives a full and complete advisement of the consequences and pitfalls of representing yourself, it is not necessary for the court to engage in a back-and-forth dialogue with a defendant. And in this case, as you indicated, Your Honor, it wasn't for lack of effort on the part of the court.
That wasn't going to happen here.
I'm sorry?
That wasn't going to happen here.
It was clearly not going to happen here. The defendant said over and over, I'm not going to participate. So the court then, and I disagree with counsel, did read verbatim every warning in the model colloquies to the defendant. He just didn't ask, do you understand after each warning, because it became apparent that that would be fruitless, that would be pointless. But I think Providence particularly, but also Vivienza, mandates a finding that the court acted appropriately here. With regarding to the hearing issue, the defendant's hearing, the 2 cases that really explicate this issue in far greater detail than any other are federal cases. Second Circuit case of U.S. versus Crandall, and an Eastern District case, Beltran versus Kaiser. And they have both said that it is incumbent upon a trial court to provide reasonable accommodations that are commensurate with what the court is presented with. Now, defense counsel says that in his brief and as well to you, the court took no measures, no accommodation measures, but that's not accurate. In both Crandall and Beltran, they said that accommodation measures will include things like utilizing a microphone, asking people to repeat their questions or their comments, which was done here. The court in this case even had the prosecutor and the defendant switch tables so that the defendant could be closer to the witnesses. The court told everybody in the courtroom, if anybody doesn't hear anything at any time, raise your hand. With all of that being said, there were about maybe half a dozen, maybe a few more times where the defendant said, I didn't catch that, I didn't hear that, I didn't understand it, and it was repeated, and he was satisfied with it. So I would submit that the court took all of the measures that were presented to it, required by what was presented to it. And frankly, you have to consider the fact that the defendant engaged in very lengthy conversations with the trial court, sometimes 10 or 12 pages long, without evincing any problems understanding the court. Engaged in direct and cross examinations with witnesses, never once asking anybody to repeat a comment, a question, or an answer. So there's just nothing in the record that warrants a conclusion that he was deprived of his right there. As for the sentence, the defendant in his brief says the prosecutor and the court repeatedly talked about a plea bargain. That's not accurate. There was never one word in the record from the arraignment to the sentence about that. The only mention of that came from late entry defense counsel at sentencing, but as I indicated in our brief, it's very likely that he was talking about a previous case that was still pending, wherein the defendant in his testimony said they offered me a plea bargain and a light sentence. I submit that the sentence that was imposed here, less than half of the maximum, was perfectly appropriate in light of the defendant's prior record, his behavior, his assault of the police officer, and his complete unwillingness to accept any responsibility for what he did. Thank you.
Thank you, counsel. Okay. Case number 219, People versus Miller.
That's submitted.
Submitted, excuse me, sorry. We'll move on to case number 221, matter of Laura A. Seeley Sick versus Jason Paul Ellis. Okay, counsel, why don't you, go ahead.
May it please the court. Caitlin Connolly for the mother. Your Honors, my client is seeking the restoration of her therapeutic supervised visitation with her children. The denial of a parent's right to visitation is a drastic remedy. Here, there is insufficient evidence establishing that visitation was detrimental to the children's welfare.
Okay, that was the subject of the testimony of more than one witness, wasn't it?
Well, Your Honors, with respect to the younger child, the mental health counselor did claim that visitation would be detrimental, but our point is that was not credible because the mere fact that the child did not wish to discuss her mother with the counselor and had bonded with a stepmother does not mean that visitation with the mother would be detrimental. With respect to the older daughter, it's submitted that the whole purpose of the prior order for supervised therapeutic visitation was to help the daughter with the issues that she discussed with the counselor. But supervised therapeutic visitation was never given a fair shake in this case because it was always remote and sporadic. And it was irregular and not in person. So the mother's limited interactions with the children were so limited that there's no basis to assume that her contact with them via regular therapeutic visitation would be harmful. Additionally, Your Honor, family court lacked the authority to condition the mother's visitation on participation in counseling, nor should the mother be required to move out of the residence she shares with her husband in order to exercise parenting time with the children, since the children do not visit with the mother at the residence. So, Your Honors, we are requesting that the court reverse family court's order and restore the mother's visitation with the children. Unless the court has any questions, I'll rely on my briefs as to the remaining arguments.
Thank you, counsel.
Thank you.
Good morning, Your Honors. I'm Edward Murphy, attorney for the children. Just as an update, I met with my clients earlier this month. Their position hasn't changed, and also family court is scheduled April 2nd as the next hearing on a petition that the mother filed that she's completed her domestic violence counseling. So it's not moot, but it's close to being moot. I think the family court record has a vast preponderance of evidence that there's damage and detriment to the children if they're forced to do visits while their mother maintains her entrenched position that she's not a victim of domestic violence. Not only is there the testimony of the mental health counselors of each of the children, but then Wendy Pinder, the supervisor, she testified the one time she met with the children, my youngest client got physically sick and had to run into the bathroom just because Wendy Pinder was there to discuss and prepare them for a visit remotely, but not in person. And then I think most notably, the mental health counselor of my oldest client, Gaffney Eaton, she testified that my client wouldn't need to be in mental health therapy if she wasn't forced to have visits.
How old are your clients at this point?
Oh, right offhand, I think my oldest client's 15, and her younger sister's 2-3 years younger than that. And again, as an update, my oldest client is not in therapy now because she's not being forced because of the pause. And again, this is a pause of the mother's therapeutic visitations. And again, we're scheduled to have another hearing. The family court has a long history with this family. That would include the judge in this case that's being appealed. April 2nd will be the third hearing that this judge hears for this family. Prior to that, there's part of the Judge Cohen's order is still included that has restrictions about the mother not being able to go to school and extracurricular events. So we've had 2 different judges have multiple hearings, and that's all part of the history. And again, the mother's counsel asked the court to take judicial notice of those prior hearings. So it's just not the record that also is in front of you, but the judge in this case is in the best position to evaluate the evidence that there is detriment to the children when the mother, at least as of this hearing, she would not change her position that she was a victim of domestic violence. That includes her pleading the 5th in the record when she was questioned about a statement she made to the state police about violence by her husband.
What's your position on the court's order requiring the mother to complete the DB counseling, which you indicated to me there's a representation that she has completed or is about to complete it, that one, and then secondly, that she no longer reside with her husband as a condition or prerequisite to visitation with the 2 children. What's your position on that order?
I think that they're proper and they benefit not only my clients, but their mother, because I think the real issue is the mother doesn't acknowledge the trauma of domestic violence that the children have experienced. In the mother's position, she's not a victim of domestic violence. And then to have the children even remotely meet with her and she wants to say, you're wrong, I'm right, rubs salt in the wound that they're trying to heal in terms of mental health.
Right, but I guess my question is was that a proper ruling for the court to make as far as that's concerned? To make those conditions or prerequisites to any access with their children?
Yes, in terms of this being a pause of the order having those therapeutic visitations. So
she's looking for therapeutic visitation again with the children, right?
Correct. Her petition was that she included that she started her domestic violence counseling. She filed that several months ago, and now we'll have a hearing in April on that.
Well, I think you're talking about the trauma to the children, which I tend to agree with the fact that the situation where the mother, rightfully or not, is taking the position of her husband that there's no domestic violence in the situation. And if the children have witnessed that in the past, then obviously there's a situation where the trauma could be affected. It's almost being revisited upon them if they're required to have any access with the mother.
It revisited upon them, they have to relive the trauma, and I think we had testimony from the oldest that she processed the trauma, and in addition, my clients, they're smart children, they understand what they experienced, and they know their mother's in danger, but mom says, right, I'm not in danger.
And it's likely to be a potential trigger upon them, again, if they're required to, again, be forced to have access with the mother. So that's a situation I guess you're going to be arguing below.
And in addition, just the prior order where the children were having supervised visits with the mother, it changed to this therapeutic visitation because during those supervised visits that weren't therapeutic, mom would try to bring in and introduce subject matters about her husband.
Right, which obviously triggered the children.
Yes.
Okay.
Thank you.
Thank you, counsel. Okay, case number 222, Cathcart versus Williams. Okay, I guess Ms. Conster is the only attorney that's checked in.
Okay, then I will keep it short and sweet. I would just like to point out, Rebecca Kantz on behalf of the grandmother who has kinship guardianship of the subject child. The family court correctly allowed the kinship guardianship petition to proceed. They made the correct credibility determinations based on the parties. The father's counsel had opportunity to respond to the grandmother's petition and failed to do so until months later. So the court was correct in denying his motion to reopen the determination on that petition. I'd like to point out that the father in this case had been included in the underlying neglect proceeding, and beyond appearing once, he failed to appear any further on that. It wasn't until the county filed for child support that he even filed a petition for custody. He relies solely on the grandmother to provide diapers and clothing for this child. Grandmother has been the stable parent in this whole situation, and family court absolutely made the correct determination. As a brief little update, since the attorney for the child isn't here, the child is still getting special education services. The grandmother and the child and his siblings have moved to Liverpool. And since they moved to Liverpool, the father is no longer exercising his Wednesday night visitations. He claimed that it was too burdensome on him to do the travel time. I'm not exactly certain how much the travel time increased, but he does still seem to be doing his weekend visitation, though that's been kind of hit and miss with holidays. So that was the update that I received from my client. And unless the court has any questions, I will rely on my brief.
I think we're good. Thank you, counsel.
Thank you.
Okay, case number 223, both video, Bowen versus Barb, or Bab, excuse me. Waiting for Mr. Broderick to check in, Mr. Hyden.
Your Honor, Mr. Broderick is in. He just has not started his video.
Oh, there he is.
Oh.
There we go.
All right, very good. Okay, very good. Okay, Mr. Hyden, I guess you're up.
Thank you. May it please the court, Lyle Hoyt, assigned counsel for the mother on this family court appeal. In preparing for oral argument, I just learned that both the mother and the both the mother and the father had filed petitions seeking to modify the order at issue. They participated in an evidentiary hearing, and their attorneys had filed written submissions earlier this month and are expecting an order from the family court. So unless that family court order dismisses all petitions, I expect that it will render this appeal moot.
And what kind of date do you have for family court? When's that?
My understanding was on February 14th, the written submissions from counsel were filed.
Okay.
We're expecting a decision shortly thereafter.
Okay. You know you have an obligation to this court to let us know when that happens, advise us of what the court has done. I'll just ask you to do that.
I will do that, Your Honor, and unless the court has questions for me, I will rely upon the argument set forth in my brief.
Okay, thank you, counsel. Mr. Broderick, anything to add?
Nothing other than this is really was a credibility determination that was determined by the court, and I think it was a decision that was minimalist. It didn't and could have changed joint to sole custody, and I believe the referee was very restrained in that. I also would tell the court my client's position is he doesn't really want to see his mom, and she doesn't visit him as often as she is permitted to under the order.
Okay. Thank you for letting us know. We look forward to hearing what happens with family court. Thank you. Okay, we're going to skip ahead a few cases to number 228, Pastrina Ortiz versus Wemple. Whenever you're ready, Mr. Willett, the floor is yours.
Thank you, Your Honor. Good morning, Your Honors. May it please the court, Michael Willett for the plaintiff, Rafael Pastrana Ortiz. We're asking the court to reverse the Supreme Court order and reinstate the complaint. Our position is that there are multiple issues of fact with regard to the enforcement of the release.
Your client doesn't speak English very well, correct?
That is correct, Your Honor. And
does he read or write English at all?
I think he can read and write a little bit. He's relied on family members to translate documents for him.
And all this came about in a very short time period, correct?
Yes, the release, the contacts with regard to the release occurred about a month after the accident, before there had been any MRIs. The only thing that we know from the medical records is that he had certain complaints of pain in his back and hips. I think this is very close to the Domenico case that was decided by this court last year, where the type and gravity of the injuries were not known to the parties at the time that the release was executed. So I think that raises an issue on the mutual mistake. We've also briefed the question of whether the conduct of the adjuster, the representation as to the effect of the no-fault laws constituted a fraud, whether it was procured on the account of fraud.
But we don't need both. We don't.
You don't need to go there, Your Honor. I mean, there are a lot. If you look at all the facts together, the language barrier, the timing, the lack of tests, the lack of representation, all that we ask, we're not asking the defendant to waive the defensive release. We're just asking for an opportunity to make our case.
Thank you, Mr. Willett.
Thank you, Your Honor.
Thank you. Good morning. May it please the court. My name is Brianna Carroll, and I'm here for the defendant, respondent Jennifer Wemple. The law of the courts, including this court, is to strictly enforce releases unless an exception applies. Here, it's our position that no exception applies and that the release unambiguously and clearly stated what it was for.
Well, it would if the person who was signing off on this understood what was going on in such a short period of time, and there wasn't much time for him to check out the rest of his injuries, et cetera, correct?
Sure. So the communication started, everything transpired about 5 weeks after the accident. And during that time, the claimant, or now plaintiff, had more than enough time to retain an attorney and to explore all of his options, and he decided not to. When the initial communications between the plaintiff and State Farm happened, there was no indication that a translator was needed or that there was a language barrier. The record also shows that there was no evidence that he requested a translator and one was denied. He had he had 5 weeks to explore his options and he opted not to. He also had the right to reject the release.
With respect to Domenico, you addressed it in your brief, and I appreciate that, and you attempted to distinguish it. You wrote that the plaintiff's medical records in that case made it plain that both before and after the release in question was signed, the professionals remained unsure whether she had a concussion. In that case, it was a concussion that was the uncertain injury, and the records reflected that. So I have in front of me page 94 of the record in this case, and it's from the neurosurgeon report well after the release is signed, May 17th. But he's referencing the hip injury, and he writes that the plaintiff followed up with his orthopedic provider, Dr. Cavagnaro, who does not believe, now this is still 6 months after the accident and after the release, does not believe his symptoms are stemming from hip pathology. So here, even 6 months later, the doctors are unsure as to the cause of the hip injury. It seems to me that that's very similar to what we have in DiDomenico with respect to the concussion. How is that different?
Sure. So in the case that you referenced, it was known that there was no idea about the concussion. Here, at least, it was noted in his initial complaints about the left hip pain, and there's a sharp distinction between injuries unknown to the parties and mistakes as to the consequences of known injuries. And here it was documented that he did have left hip pain after the accident.
So your position would be there has to be no symptom at all, no symptomology at all that could reflect the injury at the time a release is signed for it to then be later determined to be a mutual mistake.
So my position would be it'd have to be a new and distinct injury, where here it's our position that it's not new and distinct, that it relates back to his initial complaints that's noted in the record.
But again, it's only because he said he had hip pain.
Right.
That's the only thing we have. We don't have anything else beyond that.
Right, and he also signed the release, though, knowing his treatment wasn't complete and that he had upcoming MRIs.
Thank you, counsel.
Thank you.
Case number 229, Manila Center Road Associates versus Singh. My understanding is Justice Del Conte is recused from this matter. Good morning, Ms. Hoffman.
Good morning, Your Honors. May it please the Court. My name is Elizabeth Hoffman, and I represent the appellant respondent, Manlia Center Road Associates, LLC. Our briefs are pretty thoroughly comprehensive, so I just want to address a few points for you all this morning. It is our position that the merger and as-is clause contained in the lease is dispositive of the issues in this case. The response...
We're talking about a sophisticated buyer.
A sophisticated lessor and lessee, correct, Your Honor. We have two sophisticated business owners. The respondents tried to suggest that Mr. Singh is merely a taxi driver. That's not the case. He's operating a liquor store successfully. He is a sophisticated business owner who spent months negotiating with my client over the lease at issue here. The respondents looked to one comment made by my client, which is undisputed, that he states that the wall at issue could be taken down. We don't deny that. It could be taken down. The issue here is that the respondents particularly take issue with is the cost that was associated with taking that wall down. And during the protracted months of lease negotiations, my client provided the respondents with an architectural drawing that showed the load-bearing wall. My client was never asked whether the wall was load-bearing. The respondents were given ample opportunity to conduct due diligence of the space, which we suggest was insufficient, and they failed to do the due diligence that they could and should have done over the months of negotiations, and then proceeded to sign the lease regardless of their lack of due diligence. The opportunities were there. There are no misrepresentations that have been made, so to suggest that a fraud has been perpetrated when the respondents failed to do their own due diligence is just simply misplaced. Unless the court has any specific questions, I can rest on my brief.
Thank you. Counsel.
Good morning. May it please the court, J.P. Wright, Von Shedicke King, on behalf of the defendants, cross appellants. With respect to the misrepresentation, the affidavits, the deposition testimony, the notes by the non-party realtor, which he confirmed under oath at his deposition were accurate, indicate that Mr. Santero, on behalf of the landlord, advised the tenant that all the interior walls could be easily demolished. When you look at the walls, and we have pictures in the record, you can see they're covered by sheetrock in mirrors. Mr. Singh, who is a taxi driver, did not know there was a load-bearing concrete...
Taxi driver / liquor store owner, businessman.
Sure. did not know that there was a concrete, in any event, not a sophisticated real estate development.
Counsel, did I miss the word easily?
Yes, it's in Mr. Bullock's notes, which I can cite you to the record, but then I asked him at his deposition whether they were accurate. He said they were.
Because Mr. Singh didn't testify to that either in his deposition or his affidavit.
I'm going by the notes of Mr. Bullock, that Mr. Santero did not dispute that he made that statement under oath, and Mr. Bullock testified under oath that his notes were accurate.
Well, it seems that Mr. Santoro did dispute it when he said that I knew that it was a load-bearing wall and I knew it was going to be expensive, but he said he wanted to do it. You can do it if you want. So it seems that he did dispute that he said, you know, again, I don't think he was asked the question pointedly. I wonder what he would have said, but he certainly did in some its substance.
I can find the
But no, it's all right.
part in the record, Judge.
Mr. Bullock, it would be Mr. Bullock's notes.
Mr. Bullock's notes, and then I specifically read that passage to Mr. Santero at his deposition, and he did not dispute that he made those statements. Mr. Santero's position is, hey, he's a grown man, he could do due diligence, not my problem. Lee says as is, whereas not my problem. But where you have a misrepresentation like this, the lease is subject to rescission. And we have an expert affidavit that states that the walls were a latent defect. The lease specifically excludes latent defects from the as-is, whereas, merger, no representation language. Our expert looks at the pictures, looks at everything, says, no, these are hidden, a latent defect. The wall was hidden behind sheetrock and mirrors. The defect part of it is Merriam-Webster's dictionary, something that impairs the utility of the structure. Mr. Singh couldn't use this space for his liquor store. He needed a big open space. In the liquor business, theft is rampant. You need a big open space. He made this clear to Mr. Santero. Mr. Santero said, sure, go ahead and knock them all down. Now, Mr. Singh couldn't start his light demolition work until he signed the lease. He signs the lease, he goes in there, he starts knocking down some sheetrock, and all of a sudden, oh, geez, I don't think I can take this wall down. The building's going to collapse. So he asked a couple of people. It's going to cost $500,000, $600,000. Our expert states several $100,000 to remove the load-bearing wall. Based on that, the lease should be rescinded. Our other argument, frustration of purpose. The whole purpose of this lease was to open a liquor store with one big open space. And finally, Your Honors, there's no basis to have the individual defendants liable here. There's no evidence of anything that would support a veil-piercing claim.
Very good.
Thank you.
Thank you, counsel. Case number 230, Thompson versus Kuhanik. I hope I did okay there. Justice Montour is recused. Okay, counsel.
Thank you, Your Honor. Good morning, Your Honors. May it please the Court, Corey Weber on behalf of Mark Pettit and MP Construction. Your Honors, it's our position that in a case like this where a plaintiff is claiming lost wages due to injuries, but acknowledges they applied for and actually were awarded SSD benefits related to not only injuries from this accident, but also unrelated injuries or conditions in other body parts, here at the back and the knees, that the SSD records, particularly the applications, the decisions, any awards, transcripts from hearings and examinations, are relevant and discoverable first because the payments from SSD are a collateral source. We can't assert the collateral source offset at the end of a case if we don't know how much he received, when he was receiving it, and we can't do that without the awards or decisions.
Will there be an offset here because of the comp lien, or?
Well,
no, is that different?
The plaintiff has taken the position, I believe, that there wouldn't be an offset, but we cited in our reply brief, there's actually a statute in the workers' comp law because there are times when SSD payments and workers' comp payments are inadvertently paid at the same time. So there should be a recoupment of the overpayments by one of them. Here, we don't know if that occurred because we don't have the payment records. So to the extent there was no double payment, there may not be an offset. We just don't know that because we don't have the SSD records. If it turns out both were paying at the same time, the workers' comp lien would be reduced by the amount of the SSD payments, meaning the overall wage claim would also be reduced. So whether it's in the form of a post-trial collateral source offset or reduction of the workers' comp lien, we need to know that in either scenario to address.
I think it's my understanding that the court offered to be the clearinghouse to review these records in camera and to then, give to you what you are entitled to, and why wouldn't that work?
Well, what happened here, and I can't say for sure what records the court actually received, whether it was just medical records or the entire file, as I believe plaintiff's counsel has asserted. That's irrelevant because the ultimate outcome is the only thing that the court released to us were medical records related to the specific body part at issue. Right? And it's our position that we still need the application, the award, the decisions, so we know the dollar figures that were actually paid out and the timing of those payments for the offset. So I don't dispute that in certain circumstances an in-camera review is appropriate. Here, it's our position that the result of that review just was not proper or was erroneous.
I'd like to check into.
Sorry? Okay. The other reason those records are relevant is, as I said, the plaintiff admits that he applied for and was awarded benefits based on other conditions. So to the extent he's claiming that in this case that he's unable to return to work due to injuries from this accident, the defense is entitled to point to those other conditions and point out that he actually applied for and received disability for conditions wholly unrelated to this accident, to allow a jury to determine to what extent, if at all, his...
But he didn't apply until after this accident, correct?
Correct. But the two or more conditions that he listed, his back and his knees, there's no claim.
This should only go to the right shoulder and the right arm.
In this case, he's only claiming right shoulder and right arm, correct.
And he was able to go to work every day despite those other conditions. But when this accident happened, this was the catalyst for him to be unemployable.
Well, in my recollection is what the records show, that he was then cleared to return to work related to his shoulder, remained out of work because he was actively treating and ended up having bilateral knee replacements. So the continuation of his disability, we could point to, assuming we get the necessary records, we could point to those other conditions and say there's a cutoff here for when he was out of work due to this accident versus his unrelated conditions. So with that,
if there was an allegation that this is a fishing expedition type of thing, how would you react to that?
I would say it's the request is very narrowly tailored. We know he asserted these other injuries and conditions, so it's not. We're saying we're entitled to every record of any ailment he's ever had. We know he has these at least two disabling conditions. We know they're there. We just need the records to present them to a jury when this case goes to trial. So it's a tailored request for those materials on that topic. The other point of our brief and our motion was for tax records. Again, he's seeking lost wages. But when we submitted a request for records to the employer responded.
Couldn't those be looked at in camera?
They potentially could be. In this case, my recollection is the judge just denied that application.
Because there's other ways to get that kind of information rather than tax records.
Well, in this case, we went through many of those ways. The plaintiff was deposed, and in his disclosures, claimed he was working 40 hours per week for this company, earning $18 per hour or $720 per week. When we requested the records from the employer, the standard way to get the information, the employer responded and said he hasn't worked here in 7 years, which goes back to before the incident. The plaintiff's counsel will acknowledge that he was not able to get any employment records from this company. The plaintiff presented a single handwritten wage verification form from the workers' compensation file, but it's our position that that's not an accurate representation of his wage history because it's filled out wrong. It calls for the employer to list the 52 weeks of earnings preceding the incident. In this case, the employer put in, or whoever filled it out, we don't know, put in sporadic pay periods spanning multiple years, so there's no accurate representation of what his earnings were in a given year, certainly not the year leading up to the incident. And
Doesn't the workers' comp board do that as a regular matter, figure out people's average weekly wages going back, and then order payment based on that? Why shouldn't we rely on their expertise in this area?
Well, I think they're relying on getting an accurate representation on that form, which we know is not accurate. And that's the reason we shouldn't be held to rely on the workers' comp board's payment of these benefits and their calculation, because we know the documentation that was submitted to them was not accurate. And at the initial oral argument on our motion, the judge and even plaintiff's counsel said if the employment records are not available, that may swing things in favor of the defense obtaining the tax records. And up to this point, we've tried getting employment records. We've looked at this inaccurate workers' comp wage verification form, and from our perspective, there's no other way to accurately get an assessment of his wage history. And the plaintiff testified at his deposition that his income tax returns would be the accurate statement of his earnings history. So in our view, we're entitled to disclosure of those two items.
Thank you, counsel.
Thank you, Your Honor.
Mr. Nava?
Good morning. I represent the homeowner, Derek Kuhanik, and his wife, Tammy. And I would just join in Mr. Weber's arguments and otherwise rely on my papers.
Okay, very good.
Good morning, Your Honors. May it please the Court. Jason Telak here for the plaintiff respondents, Robert and Tammy Thompson. I'd like to start out just by mentioning that the trial court has very broad discretion to supervise the scope of discovery. And here, there were a bunch of issues that the trial court faced, and as limited by this appeal, we're just dealing with the tax records and the Social Security records. Now, the case law states that tax records are disfavored due to their confidential and private nature, and that the parties seeking them must make a strong showing of overriding necessity, and that the information is not obtainable from other sources. And here, the information about plaintiff's wages is readily available from other sources, more specifically the workers' compensation file.
Now, counsel just told us that it was wrong, that it didn't rely on the last 52 weeks. It took into account information that eventually gave off an inaccurate accounting of the wages.
I understand opposing counsel's position. The employer's statement of wage earnings is contained at page 649 of the record, and it indicates that it was filled out by the CFO of plaintiff's employer, a woman named Tabitha Titus, and it includes a detailed breakdown of almost 2 years of wages leading up to the date of the incident. It goes from March 2017 all the way up to January of 2019 when the incident occurred. It shows a detailed breakdown by payment period of all the dates leading up to it. Now, there's an indication on the form that the plaintiff had been laid off for a period of time, so there was a gap in some of the records. It appears in 2018. So I believe that's the discrepancy that's being referred to. And That information is indicated on record pages 650 and 651. But the wage verification statement is filled out by the CFO essentially under penalty of perjury. It states right on the document that anyone who knowingly makes a false statement or representation shall be guilty of a crime and subject to substantial fines and imprisonment. So it's pretty safe to say that this document was filled out with reasonable accuracy based on the information that was in plaintiff's employment file. And in addition to the documentation and the workers' compensation file, during the underlying motion, plaintiff agreed to cap his lost wage claim at the amount of wages that were paid out by the workers' compensation carrier for past lost wages. So that's all we're claiming in this case, is we're trying to recover the lost wages the plaintiff was paid by his workers' compensation carrier. Not future lost wages, not anything else, just what was paid by the workers' compensation carrier. So unless there are questions about the tax records, I'll move on to Social Security records.
The amount paid by workers' comp, that's an amount that will be clawed back, so to speak, by a lien.
Correct, Your Honor. And we have provided those lien letters to opposing counsel and to the court. And the amount paid so far is $68,825.50. So it's an amount that can be determined with reasonable certainty based on the documents in the workers' compensation file.
Okay.
So with respect to the Social Security records, this court has consistently held that Social Security records should be reviewed by the trial court in camera to make sure that no irrelevant or privileged information is disclosed. I'm not aware of any cases that stand for the proposition that defense is entitled to unfettered access to the entire Social Security file. Cases from this court, there's Snyder versus Asher, Boya versus Benz, both decided within the last 12 years. All say that in-camera review is appropriate to make sure that only relevant information is being released. And we agreed to do an in-camera review in this case.
And the court did that, right?
And the court did that.
And kicked out some documents?
Correct. And contrary to what was included in the briefs, we didn't only submit the medical records. The authorization that was sent to the Social Security office is actually contained in the record. And it shows that we requested the monthly payment and benefit amount, the complete medical records, awards, denials, notices, benefit applications, appeals, questionnaires, doctor reports, and so on. And the reason we couldn't request the entire file from Social Security is the authorization specifically says you can't do that. You have to itemize the records that you want. So we tracked the language on the authorization to make it as broad as possible. We submitted those records to the court. The court reviewed it and agreed with our position that just the medical records related to the body parts at issue in the case were discoverable.
Well, what about counsel's position that it takes knowing, you know, the big picture, the plaintiff's entire health photo to be able to figure out where they're going in this case? You know, what kind of, award might be payable at the end? What about that?
So plaintiff was a laborer. He was a construction worker working full duty up until the date of the accident when he slipped on ice and hurt his shoulder. He came out of work after that point. He had 3 surgeries on his right shoulder, including a right shoulder replacement. There was a scheduled loss of use hearing that attributed 48.3% loss of use specifically for the right shoulder. So it's respectfully submitted that it was the right shoulder that took him out of work, and the evidence in the case supports that. Additionally, we're only claiming wages for past stuff related to the shoulder. We're not claiming future things that could be related to the knee or the back. We're very limited in what we're claiming in that respect. One other thing to mention about the workers' compensation law, section 15.3v, that was raised for the first time in the reply brief. That's not something that was ever argued before the trial court. It wasn't included in the initial brief. It came to my attention on the reply brief, so I looked it up, and it looks like that section deals with additional compensation for impairment of wage earning capacity in certain permanent disabilities. And it talks about if there's a loss of use or 50% or more of a body member, there are additional payments and there can be offsets with Social Security for those. That's completely inapplicable to this case, where there was a 48.3% loss of use. It seems to be completely irrelevant to the facts of our case. And again, we're not claiming future wage loss, so Social Security payment shouldn't be an offset for any future wage payments since we're not claiming them.
Okay,
Okay?
okay, thank you, counsel.
Thank you.
Okay, case number 236, Miller versus Lomp. Both video. Oh, good morning, counselors. Can you hear us? We can't hear either of you.
Both maybe.
I think I'm unmuted.
Try this again. Is this a bit better?
There you go.
Thank you.
We're very good.
I confess at my age, Zoom is a little new to me.
All right, so we're ready to proceed. Mr. Goris?
Thank you, Your Honor. May it please the court, this motion pertains, as Your Honor is aware, to a summary judgment motion that had been brought below by defendants. This matter arises out of an incident involving defendant's dog, Bear. I believe the facts are fully set forth within papers. Motion was brought on the basis that the plaintiff has failed to produce any evidence to support an argument that there was notice to the defendants, prior notice to the defendants of this dog's proclivities that would have led them to anticipate that this incident might have occurred. The plaintiffs have responded with a series of cases arguing that the nature of the incident itself was sufficient to arise to notice. We briefed and addressed those cases. Two of the cases that they have provided to the court actually give any description of the underlying incident, and I think it's clear that the incidents involved in the cases where the courts found that the incident was sufficiently severe, significant in and of itself to give notice or create notice are distinguishable, readily distinguishable from the facts herein.
Counselor, you just to be clear, you said the facts are not really in dispute, and two facts are not in dispute: that your clients had Bear enrolled in, for lack of a better word, specialized training so that he wouldn't pull on a leash. And then in addition, while Bear was tied at the campsite, he had on a pinch collar, as your clients described. Correct?
That's correct, Judge. And I believe acting as responsible dog owners in doing that, and I'll move to that because that seems to be where the lower court based its decision here, saying that, well, this proclivity to pull at the rope or a leash, that was notice of this potential.
I assume it's probably your position that that's not a propensity for viciousness.
It's not a propensity of viciousness, nor is there notice of viciousness there. I don't think that a dog pulling on its leash is anything unusual. It's just like dogs barking as a matter of course. It's what dogs do. What's absent in this record is any evidence that when Bear had pulled on a leash in the past and the behavior that my clients tried to get addressed, he hadn't been growling or barking or yapping at dogs, indicating that he had any intention, any proclivity for doing anything other than wanting to go up and see other people or dogs while he was out being walked. That again is not an unusual behavior, I would submit, for dogs, and there's nothing in that in and of itself that would have put my clients on notice that, holy cow, if this dog were to get away from me, I'd really have a problem here, because there is no attendant indicia of any viciousness or aggressiveness described anywhere in the record that went along with that general pulling or tugging on a leash.
So Counselor, just to be clear, your clients understood that their dog liked to pull on a leash. Your position is that being true, that's not a vicious propensity under the law.
It's not a vicious propensity under law, and I don't think that there's anything in and of that action that would have put them on notice that an attack of some kind was going to be imminent if the dog did pull on the leash, or alternatively, if the dog was off leash outside. Focusing on this pulling on the leash, to me, it's like, well, the dog enjoyed car rides, and we took him on a car ride, and when the car door opened, he walked out, he ran out and engaged in an attack on a dog.
But I think what the plaintiff is saying here in this particular case, the dog's proclivity to pull, particularly in the presence of other dogs, is exactly what caused the accident or incident here. That your clients knew that the dog was likely to pull, which is one of the reasons the dog was tied with the pinch collar, and that pulling resulted in the incident.
I'm sorry, I'm just not able to put those two together, Judge. I think you're joining a subsequent act here, conflict with the dog, to what is a distinct and separate and independent act, pulling on a leash. I don't know that there's anything about any dog pulling on a leash that would lead to an inferential jump that, well, because this dog pulls on a leash, therefore there's going to be some kind of a hostile encounter if the dog gets away or if the leash breaks. Again, the pulling on the leash is a normal activity of a dog, I would submit. Any dog I've ever had, certainly, that's one of the things that you encounter. Just like barking for a dog in and of itself is not sufficient to then say, okay, he therefore is going to have a violent encounter of some sort down the road here. Here, this is a normal activity of a dog pulling on a leash. There is no logical, necessary connection between pulling on a leash and then having an incident like this occur.
Okay, so just so that I'm clear of the argument, you're suggesting it was foreseeable to your clients that if another dog walked by at this campground, of course there's lots of dogs all permitted to be, that it would be reasonable, they would be reasonably foreseeable to them that their 118-pound dog would pull hard enough on this clothesline that they had attached him to, and it would even be foreseeable that he might break the clothesline or have it pull free from the tree. And so that was foreseeable. What wasn't foreseeable is the fact that the 118-pound dog, running toward the other two dogs with the owner holding their leash, that an injury would result from that. Is that right?
No, Judge,
That's the break.
I don't know that that's right. I think it was certainly foreseeable based on the dog's history, and again, any dog's history in my experience, that the dog might pull. I don't know that I would go so far as to say it was foreseeable to my clients that the dog was going to break that clothesline. And again, I would also say that let's put this in a different manner. I would go so far as to say, okay, if the dog ran off the leash, and as I indicated in the papers, or broke that rope and the rope swung and snapped and struck somebody nearby in the eye, okay, there's a connection there between the two things. There's a nexus between the pulling and the breaking of the rope and the injury or the nature of the damage or harm that followed. Again, looking at the Court of Appeals, the nature of the injury, the nature of the event has to be the proclivity that we're on notice of. We're on notice of a proclivity to pull on a leash or a rope. That doesn't lead to a proclivity to have this kind of an interaction with this dog and result in this circumstance that we have here. So I think there's a clear dividing line here before what we were on notice of and then taking that leap to say, well, we were therefore on notice that the dog was going to have a hostile interaction with this other dog.
We also know, that they're also on notice that the campground required that the leash be limited to 6 feet. Do we have any issue of fact as to whether that clothesline, when fully extended, was longer than 6 feet? Because of course then you could get kind of a running start. You could get more momentum going. It could be more dangerous.
Well, I don't know that makes the dog more dangerous, Judge. It may make it more likely that he, as you say, he gets momentum and the leash snaps. But now we're moving from an incident involving a dog and the standard of proof there and what's at issue to, it sounds more of a general negligence theory, perhaps, that Your Honor is suggesting here that, well, if we'd had a shorter rope, maybe this doesn't happen. The same is true, I suppose, if they had a chain or a different type of rope or leash involved here. So can certainly go down those roads, but I'm not sure they lead us to the legal standard or what's really at issue here.
Okay. Thank you, counsel.
Thank you.
Okay, counsel, it's your turn.
Yes, hi, might it please the court. My name is James Shuttleworth, and we represent plaintiff respondent Miller. I have to say that the dog's defendant's prior knowledge of the dog's proclivity to pull so hard at the leash that they got not only specialized training, but a pinch collar as well, is indicative of prior knowledge. Relevant, I believe, is a Supreme Court case of Westchester I cite in my brief, Grimes versus Latimer, which held a pinch collar on a dog indicates they knew the dog possessed a risk of chasing others. With regard to chasing, I don't agree with counsel that the fact that the plaintiff was not injured by the broken leash is relevant. More relevant is the dog's proclivity to pull so hard at the leash that he broke the collar, ignored his pinch collar, bolted across some distance. The attack persisted. Plaintiff's dog was bitten. Plaintiff was bitten. Plaintiff was knocked over, sustaining what we allege were serious injuries. And it took not one, but both defendant dog owners to pull him off. Now, defendant argued in their brief that, well, the attack didn't last long enough to be considered severe. Well, the only reason it didn't last longer is because they pulled him off. Again, as was held by the Court of Appeals in Collier versus Zambito, an animal that behaves in a manner that would not necessarily be considered dangerous or ferocious, but nevertheless reflects a proclivity to act in a way that puts others at harm or risk, can be found to have vicious propensities. So, contrary to counsel's suggestion, it is not the nature of the injuries, bitten, knocked down, or whatnot, that is relevant. It is the severity of the attack, in this case, the nature of the attack and the resulting injuries. I submit here that it is the unusual nature. This is not a typical canine, pulling at a leash a little bit, tugging a bit. No, this dog, as the court pointed out, broke a clothesline leash, ignored a pinch collar, attacked plaintiff and his dogs, biting them both and causing injuries. Sorry about that. I thought he was out. That gives rise to this.
So, counsel, I think it's your argument that you'd like a jury to decide.
Oh, absolutely,
this issue.
Your Honor, absolutely.
What was known and whom it was known to and the extent it was known, you think those are all questions of fact?
Oh, most certainly.
Okay, I think we have your argument.
I'm perfectly happy to rely on the rest of my brief.
Okay, thank you very much,
Thank you
counsel.
much, judges.
Okay, then I think the rest of the folks here are here on a variety of cases. Case number 224, 225, 226, 227, 232, 233, 234, and 235. Okay, I think I mentioned them all.
Yes, there are 8 cases.
Okay, 8 cases. Counsel, come on up. And let the record reflect that Justice Del Conte is recused on this matter.
Thank you, Your
Counsel?
Honor, and may it please the court. Michael Nicholson on behalf of Appellant, the Cayuga Nation. This is the first of 8 appeals, as Your Honor just mentioned, before the court today brought by the nation. Each of the appealed orders is identical, and the substantive facts and arguments in the briefs are the same. Accordingly, I will present my arguments as follows to the court across all 8 cases, if that is permissible.
Oh, that's perfect.
The Cayuga Nation is a federally recognized Indian nation with a federally recognized reservation. As a sovereign Indian nation, it unquestionably has the authority to establish its own judicial system to resolve internal disputes. This case involves a monetary judgment for unpaid rent issued by the Cayuga Nation Civil Court in an action brought by the nation against a nation citizen relating to the occupation of nation-owned property located on the nation's reservation.
Is that nation-owned property owned in fee then? It's not held by the United States government in trust, is that correct?
My understanding is it is owned in fee by the nation. It is not part of lands that have been taken into trust.
Thank you.
No part of the judgment is attributable to taxes or to fines or a penalty.
The record doesn't really show what these monies are for.
Well, Your Honor, if you turn to the record, I can point the court to the page, but I can state more generally.
But there was no lease in the record, right?
There's no lease in the record, but the Cayuga Nation Civil Court order specifically says that it's for unpaid rent for the occupation of property. So when you look...
There's nothing that we have to determine what the amount of the rent is or what periods it's for, or whether or not there's any interest or penalty with respect to non-payment of that particular amount.
Well, I think it's clear from the face of the order that it is a non-payment for occupation order. It does state the amount of damages, which would be the lease amount, and it does state
Again,
interest
I
and
don't
costs.
know. I don't know from looking at the record. You know, what's the term here? Was it a oral lease? Was it a written lease? Was it a term? You know, I don't know what the amounts of the rents were for any period. There's nothing in the record with respect to that other than saying that it was rent.
I believe, Your Honor, that's correct when you go to the granular, but when you go to the overall representation of what the judgment is for, it's clear on the nation court order. But I would also say to the court that Article 53, as this court made clear in Parker, applies to nation court judgments. And Article 53 does not envision, nor does it require, a scrupulous and exacting review of all the underlying merits of any foreign judgment, whether that be from Canada or from a country overseas or a sovereign Indian nation.
I think also, I don't think you disagree with me that there's still a requirement that you demonstrate that the tribal nation court had jurisdiction over these individuals.
So, Your Honor, I would disagree with the court on that. There are 2 provisions that apply. There's 5302 and there's 5304.
Isn't it similar to the Guerra decision, wherein the court in that instance indicated that there was no evidence that the court in Paris had jurisdiction over the individuals? There was no applicable affidavits of service that were made against these individuals in that case. It's similar here. We don't have any record that shows we're bringing this action in the nation court. Here's our affidavit of service.
I think, Your Honor, you'd have to look to only...
Giving you personal jurisdiction.
Well, to start, Your Honor, the record does reflect in the nation court order that personal jurisdiction was obtained by service upon the respondent.
There's no affidavit of service, though.
There's not an affidavit of service for the nation.
There's no lease.
There's no lease. But I would say, Your Honor, in response to your initial question, the court would have to look only to cases that post-date the 2021 amendments to the CPLR. In those amendments, as set forth in our brief, the burden is shifted and expressly lies upon the party resisting resignation to speak to personal or subject matter jurisdiction.
You're saying it's the respondents here burden to show that there was personal jurisdiction in the tribal nation court?
I'm saying yes, that is specifically what 5304C says, and it's detailed in our brief. It specifically places the burden for subject matter jurisdiction and personal jurisdiction under 5304 on respondent, and I would refer the court to its decision of July 3rd in the Parker case, where the court said because 5302 applied and there was a fine, the burden never shifted to the resisting party under 5304.
And that is-
But those
and that-
burdens are subject matter jurisdiction and personal jurisdiction.
In that instance, it's because there were fines that were attributable to those particular judgments, and under 53, no one can enforce those fines.
That's right. But that's what distinguishes that case from this case.
But, okay, you distinguish it based upon the fact that this is a lease case or a rental case, is that right? They're non-payment.
I distinguish it from the fact that that case involves something that is expressly announced under 5302 as prohibited from recognition when it's a foreign court judgment. Taxes, fines, penalties, or domestic relation orders.
Right, and
those
again-
are the prohibited categories. This case does not fall within those prohibited categories, which are the movant's or the petitioner's burden to satisfy. But the other bases for discretionary or mandatory non-recognition under 5304C are expressly the burden of the party resisting recognition, not of the petitioning party. And so that distinguishes that case from this case. We fall within 5302. Nothing prohibits the judgment from recognition, and we satisfied our burden to the court
So
of
you're saying
demonstrating.
nothing prohibits domestication of this particular judgment? Is that what you're saying?
Yes, and I'm saying specifically, when we look at the trial court and the burdens below, the burden on the nation was to demonstrate that its application satisfies 5302. It did that. Any burden to demonstrate that it didn't meet the bases for mandatory or discretionary recognition were the resisting party's burden. They didn't make those arguments below. They didn't raise them to the court. They didn't meet their burden, and the court didn't have the ability to sua sponte go through 5304, and it didn't do that in any case.
Well, you're looking at domestication under 202.71, right?
Yes, which this court has made clear then makes you look at Article 53.
Which, again, is based upon comity, correct?
That's correct.
All right. And comity is based upon jurisdiction. And it's
A predicate.
among others.
Yes.
Right. The court can look at determine whether or not there was jurisdiction at the lower court, and determine at that point in time that we're not going to domesticate this based upon the fact that there's no evidence here that there was personal jurisdiction over these individual respondents.
When you say lower court, Your Honor, do you mean in
On
this
the
case
tribal
the
nation
nation
court.
court?
Yes.
No, I don't think that's correct. I think the legislature, when it amended 5304C, said those burdens must be raised by the party resisting recognition.
202.71 is distinguishable to 53, Article 53.
It's distinguishable in announcing a vehicle to get to Article 53, but this court made clear in Parker that when you look at 202.71, it does go through and implicate Article 53, because all judgments that seek recognition
It has, right.
go into Article 53.
But again, it's all still based upon comity. Whether or not, jurisdiction is here, whether or not, that's my argument here, is that under comity, the court below has the authority to determine that there was no jurisdiction, therefore, we're not going to. Again, it's looking at all the paperwork that's been submitted, including the petition under 202.71. There's nothing in references to your petition that you had personal jurisdiction over this individual, such as copy of an attachment of a affidavit of service.
Well, I think that the
which the petition rightfully requires.
Well, the nation court order does say that personal jurisdiction was obtained, but I'd like to frame this to the court.
We're not going to get anywhere with our arguments. I guess we're going to agree to disagree, but go ahead on another.
I'd like to frame this before the court on how we actually got here, which is the procedural posture. This was a motion to vacate. It wasn't a petition that was denied. Justice Odorizzi granted the nation's petition to domesticate the judgment on default, and that judgment went unchallenged for more than a year and a half until a different judge, Justice Porsche.
How are they going to challenge that?
By making a motion to vacate.
Yes, they did.
Yes, but I would like to explain to the court why they did that, which is critical to understanding the merits of the case here. A different judge, Justice Porsche, in different proceedings.
Because Odorizzi is not available anymore, right?
Yes, there is a different judge.
Right.
Justice
Odorizzi is not available anymore, so they went to a different judge.
Yeah, so a different judge gets the case, and that judge had previously issued a decision in different proceedings declining to domesticate a different nation court judgment. And only when that judge issued that decision, based upon that decision, did respondent file the motion to vacate. And he filed the motion to vacate under 5015A5, which is a mechanism to vacate when an order has been modified or vacated. So he took the precedent that he alleged Justice Porsche set. He made a motion based upon that precedent, and he asked the court to effectively apply that legal precedent to the same trial court, but a different judge, and overrule Justice Odorizzi's domestication of the petition. So we're here on Justice Porsche's decision and his announcement that he could apply it as binding precedent under 5015A5 to basically upend and vacate the valid order entered by Justice Odorizzi. So this isn't a petition of first instance. The petition was made and it was granted. They lie in wait, they get a decision, they claim that's binding precedent. The case goes to the judge who issued that ruling. He applies it as binding precedent. But I'd like to explain to the court why that was such a mistake and why it must be reversed here. His entire decision was based on the erroneous claim that the Cayuga Nation does not have a federally recognized reservation. He says it at record page 28 in our decision, and he renews that at record page 3. And based upon that determination, he says that the Cayuga Nation does not have authority to issue judgments. That was an reversible error for at least 3 reasons.
Does it indicate that they didn't have subject matter jurisdiction basically over this?
No.
Because the fact that the property was in Seneca County?
But that demonstrates the mistake he made. What he says is the nation does not have a federally recognized reservation. Because of that, he says, all land is Seneca County. There is no reservation. So the predicate for his whole decision is the announcement that there is no federally recognized reservation. That is flatly incorrect. Every federal court to consider the issue has concluded that the nation's reservation, as established by the Treaty of Canandaigua, continues to exist, and so has the Court of Appeals in Gould. I would also note that the Treaty of Canandaigua created the Oneida and Onondaga reservations. But second, in staying on the procedural posture here,
Does that piece of property that are related to here is in Seneca County held by fee? Do they pay taxes?
I'm not aware of the answer on
Okay.
that.
Thank you.
But that wouldn't reduce the nation's court ability to assert jurisdiction over property that is on the federally recognized reservation. And so 5015 rather doesn't provide the authority for what happened here, which is a court of coordinate jurisdiction taking its decision and using it as a basis not to announce in the first instance, but to upend and vacate the valid order of another judge. That's not permissible. And the interest of justice, no matter how broadly applied across the sweep of 5015, and we argued to the court in our papers that under first and second department precedent, it's not boundless, it's not plenary, and those courts cite the Court of Appeals decision in McKenna. But no matter how broad the interest of justice, they cannot support a ruling based on a flatly incorrect premise that defies federal and Court of Appeals precedent, which is the Cayuga Nation has a federally recognized reservation. Third, there's no basis to uphold the decision like the court did in Parker on alternative grounds because CPLR 5302 was satisfied here. The nation court judgment is a foreign judgment that is final, conclusive, and enforceable where rendered. Every argument that respondent makes on this appeal comes under CPLR 5304, under which the respondent, as I said before, the party resisting recognition has the burden. Subject matter jurisdiction, personal jurisdiction.
So then your argument is that there's no prima facie burden at all on a party seeking enforcement of a foreign judgment. Photocopy of the judgment, perhaps. That's it. That's what you're claiming your burden is.
I'm not saying that. I'm saying our burden is codified in 5302 to prove that it's a judgment that is final, conclusive, and enforceable where rendered, that it's for an amount of money, and that it doesn't hit any of the prohibitions of 5302, fine, penalty, tax, or domestic relation order. That's the prima facie burden, is
So
to
as
demonstrate.
long as it's called something different, in this case, called rent. A lot of ways you can get to additional rent can be a penalty. You can do that if you want. I mean, we don't know because we don't have the underlying papers, but as long as you call it something different, you meet your burden.
Well, I don't think when the court looks at comedy, it's that suspicious of valid foreign courts, whether that be the Court of Canada, the Court of France, the Court of the Sovereign Cuyahoga Nation. There's a certain amount of trust listed within comedy, which is that if we had a judgment from, say, a Canadian court, the Ontario court, there would not be an expectation that the movant or the petitioner attached to it volumes and volumes and reams of identifying evidence, because the whole purpose of affording to the court comedy is we have trust of its determinations and its decisions and orders. It's not an opportunity for the New York State court system to somehow look to undo or renew a decision of a foreign court. And in fact, the federal courts have said a number of times that exercising such a paternalistic approach to Indian nations undermines the sovereignty they've been given by the federal government, and they've always had. And so it's not an opportunity to look into and relitigate every aspect of a foreign judgment. We wouldn't do that with Canada, we wouldn't do that with France.
And that's the purpose of 20271, is to not to have to relitigate that.
Yes.
Right.
And I think that's the same point as I'm referencing with the other foreign nations. So
It's the same thing as the Wary case, though, but they said in Paris they didn't demonstrate any evidence of jurisdiction over the individual.
But I'm not sure that case postdated the 2021 amendments. Because it's those amendments, and we explained that in our briefs, and it's detailed very clearly, those amendments took the burden from where they originally lied on the petitioner and placed them squarely and exclusively on the respondent or the party resisting recognition. That's what the legislature chose to do. So anything prior to 2021 is irrelevant as a matter of precedent to how the rules and procedure play out now.
So you consider it too paternalistic, so to speak, to require, affidavits of service on the various people who you have judgment against, and the basis for the judgments, meaning, in this case, there are leases. So those two pieces of paper, if we required them, we'd be being too paternalistic? Is that what you were saying? That it requiring more than we would of even ourselves on another state's judgments?
That's right. I think that's exactly right. When it comes to Pennsylvania, if you had a judgment from the court in Pennsylvania, the court wouldn't say, let's relitigate the merits of this judgment here. Attach to me everything that supports the judgment so we can decide de novo whether or not we're going to afford recognition in this state to that judgment. The purpose of comedy is there's a matter of fraternity or sisterhood or brotherhood between sovereigns.
But even in New York State, you want to get a default judgment, you usually have to show, even just the clerk of the court, that there was, a contract or a lease, and or that it was served. Okay, that's part of what the judgment roll would look like in New York, wouldn't it?
When it comes to a default judgment, but this isn't a default judgment. We're looking at recognition by way of comedy, which again...
But the underlying was a default judgment.
The nation court judgment was a default judgment.
Right, that's what you're looking to domesticate.
Correct. But we have trust as a state that entities to which we afford comedy, whether they're Canada, France, Pennsylvania, or the Sovereign Cuyahoga Nation, have gone through the process appropriately. If not, there'd be no purpose for comedy. You would just have to relitigate things anew in the Supreme Court every time you're before it. There's a certain amount of good faith and trust that's vested and lies within a recognition under comedy. The nation should not be treated different than any other entity to which New York's government affords comedy. And I don't think that if this were a domestication application from a Pennsylvania state court or Ontario, that the court would ask, or that any court would or should ask, to see every aspect of what may have been litigated before.
I don't think anyone's looking to see what was litigated before. What they're looking for is whether or not there was a proper service of these individual defendants in the tribal nation court.
And I would go back to say...
I don't think that's allowed to happen.
No, not even proper, any service.
The order does say in it that there was service, but also we trust...
But your application says nothing about, your petition for recognition says nothing about jurisdiction.
Because it's not the nation's burden under 5304C.
All right, we're going to get in. Go ahead.
But that's the argument that you make. I mean, you started with sort of reams and reams of paper. And I got kind of hung up on that, thinking about that, because it seems to me that what's being essentially looked at as being perhaps deficient here are a couple of sentences. A couple of sentences in the petition saying this is how it was served, this is what the controversy was about, this is the reason for the default below. It seems to me, and frankly, even in terms of paperwork, it would seem in this age of electronic filing that it really wouldn't be burdensome at all. It would take seconds to make it much more clear to the court here as to what the details were as to the underlying judgment without any additional significant time or expense. But there was sort of a choice not to do it on a default judgment below. And so that sort of raises a little bit of the question. Your response would be, well, the legislature doesn't require it based on the 2021 amendments, right? That's now their burden.
Yeah, that's part of the response.
What's the rest of it? What's the rest of the response?
Well, again, I would go back to what I said before. We're here on a specific procedural posture. We're not here like we were in Parker, where the judge in the first instance declined to grant a domestication petition.
Your procedural posture is again 20271?
No, the procedural posture here is respondent made a motion to vacate under 5015A5. Justice Porsche granted that motion to vacate. The appealed order is an order granting a motion to vacate. We didn't appeal an order of Justice Porsche or any other justice who got the petition anew and declined to domesticate it. The appealed order in all 8 cases before this court is an order granting a motion to vacate under 5015A5. That puts this court on a different procedural posture. The question before this court is there a basis under 5015A, whether under any of the enumerated provisions or the broader interest of justice, to vacate? And a basis that doesn't exist is for a judge to take his ruling and apply it as binding precedent when it's based on a false premise and upend and vacate a judgment. That's what the order appealed makes specifically clear. He vacated the judgment of Justice Odorizzi, and he said, quote, it would be an inconsistent application of the law. He announced that he was applying the law. Gone is any pretense of a fact-based determination. He didn't say he was making one. He said he was vacating based upon his decision in another case. And that decision was squarely placed upon his determination that the nation doesn't have a federally recognized reservation.
Okay.
So
I think we've got your argument.
So if I could, Your Honor, a couple other brief points, since we do have a number of cases, and I intend to, if I could, argue them all at once here. To go back to what I was saying before, because respondent did not raise any 5304 arguments below, it could not possibly have satisfied its burden to Justice Porsche, even if the court were to look at the interests of justice. And likewise, because those arguments, subject matter, personal jurisdiction, were not raised below, they have not been preserved on appeal, and they're not properly before this court. But even if those arguments were before the court, as set forth more fully in our briefs, they're without merit. And I'll briefly explain why, because I think when you hear from opposing counsel, the main focus of his argument isn't going to be about defending the appealed order, it's going to be about attacking the nation's judicial system. To begin, respondent argues that the nation's trial court judge was not validly appointed, but the nation's highest court, the Cayuga Nation Court of Appeals, by Judge Carney, has determined that the trial court judge was indeed validly appointed under the Cayuga Nation judiciary law. And under United States Supreme Court precedent, that determination is binding on this court. Respondent also argues that Judge Fahey is somehow limited by his engagement agreement to presiding in only criminal matters. But when the agreement is read in its entirety, it's clear that he has been appointed to preside in both civil and criminal matters. And that has been confirmed by the fact that he has indeed been presiding as the nation's civil court judge for the past 7 years. So clearly he's engaged by the nation to do so.
There was an amendment to that judiciary law, though, taking out that provision that the judge be a member of the Cayuga Nation. Isn't that correct?
There was an amendment, but I would refer the court to what I just said, which is that this specific issue was taken on appeal all the way to the nation's...
This says a yes or no answer.
If I could just add, that issue of the application of the law to judges who are not citizens of the nation was taken to the nation's highest court. It specifically addressed the language and application of the nation's judiciary law, and it held that Judge Fahey was validly appointed under the Cuba Nation judiciary law. It also since amended the judiciary law, which clearly says that it applies retroactively and going forward, but that decision by Judge Carney is binding precedent from the nation's highest court, and under the Supreme Court's precedent in Wainwright, it is applicable and binding upon New York State courts. Respondent also argues that Judge Fahey is not independent because he says his compensation can be altered at will. That is not true. The Cuba Nation judiciary law specifically states the compensation of judges shall not be diminished during their term of office unless a majority of a particular court votes to reduce that entire court's own compensation equally for that court's term. That's in the record at page 56. Respondents' reliance on a particular provision of the engagement agreement that allowed the parties to revisit compensation only within the first 3 months of the position being created ignores the fact that that engagement agreement says this is a new position, and the parties recognized that they needed to get a better understanding at the very beginning of how much of a workload was involved. And so they had that 3-month period, which expired several years ago, to get an understanding of what the workload was. That provision is no longer operable on its own terms. And again, the judiciary law prevents any reduction in compensation. Lastly, respondent says that the engagement agreement raises due process concerns because it allows either party to terminate it at will. That argument fails as set forth in our brief because due process, in fact, permits the use of agreements for adjudicators that allow both parties to terminate at will. And I'd refer the court to the D.C. Circuit case we cited in our brief. Ultimately, the Court of Appeals in Campbell encouraged the nation to set up its own judicial system, and it did just that. It has put in place a judiciary law and rules of civil procedure that fully ensure the parties before it are afforded due process. And again, I'd like to reiterate, because there has been a lot of argument about it in respondent's brief, that this court's July 3rd decision in Parker is not on all fours here and does not apply. That court dealt with the recognition before it of a fine. It found an alternate basis to uphold that the judgment was not appropriate under 5302. This case involves a monetary judgment for unpaid rent. It satisfies 5302. There was no basis for Supreme Court to vacate it, and the record plainly reflects that the only reason it was vacated is because the judge determined the Cuba Nation's reservation doesn't exist. If he didn't make that determination, which is flatly incorrect, he wouldn't have made his determination that that was the law. It was an error for him to apply his own decision as binding precedent under 5015. Again, the procedural posture here is a motion to vacate, not an initial application for domestication. And so within the parameters of what's appealed before this court, this is an abuse of discretion that cannot be saved. If there are any further questions, I'm happy to answer them.
No, I think you've explained it well. Thank you.
Thank you, Your Honor. I'll rest on my papers.
Thank you.
Good afternoon. May it please the court, I'm Joe Heath, and I appear here for the respondents in all 8 cases. They're identical. We've established that. The main brief by the petitioner has 2 arguments attacking the motion to vacate. They attack it procedurally. They seem to have backed off from that position now. And they attack the fact that the lower court granted that motion. Then they improperly raise Article 53 arguments before this court when they never raised them at all in the lower court. You won't find the term Article 53 in the petition. It's not in there. How you claim to satisfy a state law that they're arguing they've satisfied without even mentioning it is creative. Let's go back, and we'll come back to that more and more. It also goes to what is properly before this court because the November 2023 decision in order that vacated does not mention Article 53. It is not a final order. Therefore, the only thing before this court is whether or not the broad discretion that applies to motions to vacate was properly granted in this case. And we clearly say that it was. So,
Counsel, there seems to be some argument that it was improper for Judge Porsche to make a decision which affected the order of Judge Odorizzi. That's, can you speak to that?
that's what motions to vacate set up, Your Honor. And we have found out since we found out that Judge Odorizzi went to the Court of Claims, so he's not available. So we filed a motion to vacate. We never claimed it was binding. Those words are not in any of the papers, either in the lower court or here. We never claimed that it was the law of the case. So the original default judgment was issued in 2021. In April of 2023, Judge Porsche issued a different order in a different case. The same court, the same petitioner brought against the Cayuga Nation citizens. They couldn't be more identical. This is not some court of coordinate jurisdiction, and those arguments should be just disregarded. So here we have a court faced with a contradiction. It has one ruling that says we'll honor this, a default judgment, not on the merits. And the state very much prefers that we decide things on the merits. And so what's the court to do? It's got to resolve that conflict. That's what it did. That's all it did here, is that it vacated the judgment so that it can go back to Supreme Court and all of these issues about Article 53 remain there. That's what would be taken up when you deny this appeal, as you should. And motions to vacate under 5015 should be decided under the broad interest of justice. This was a very reasonable decision for Judge Porsche to come to. We have conflicting orders. We'll vacate the default judgment and we'll go back and litigate the case on its merits. That's all you're supposed to be reviewing today. That's clearly within the broad interest of justice. We have briefed this repeatedly. It's a 140-year-old principle.
Now, can I ask you, do you think it's too much, too paternalistic for the state of New York to request and view things that are indicia to our judgments of trust, meaning affidavits of service and leases underlying judgments?
I need to correct one argument that was made. Pennsylvania does not fit into the argument before the court. Pennsylvania is granted full faith and credit under the Constitution. This is a foreign court judgment. What this court should do is apply the CPLR. They can't just come into court and say, we have a default tribal court judgment. 20271 entitles us to recognition. That's what they argued last year. The court corrected that. In fact, there's a very clear quote from Parker that says, merely filing your tribal court judgments or your foreign court judgments does not satisfy all of the requirements of Article 53. They satisfied none of the requirements of Article 53.
We have a question raised, though, about the burden, that the burden changed through the legislature in 2021 amendments to 5304C. And I see the argument made in their reply brief. I'm not sure which case it is, but they're all similar. pages 7, 8, 9. What's your comment regarding that, the change in the law, and that now that becomes the respondent's burden?
That argument is not properly before this court.
Because it was raised in reply.
Raised for the first time in reply, which gives us no opportunity to answer it. And those issues will go back now to the Supreme Court. What would be pending there, if the motion to vacate is affirmed, is whether or not these totally inadequate papers that they filed satisfy their burdens under Article 53. You probably should mention, what happened here is that, this is my guess, is that when they filed these in June of 2021, they were not aware that Article 53 applied. I think if you read the 6 cases we argued last year and these 8, that's pretty clear. They never even mentioned the law under which they have a burden. The burden can't shift to us until they show that they're entitled to Article 53 applying to their judgment. They didn't do that. Therefore, we shouldn't even be here on this issue. The motion to vacate was a proper granting of discretion by the lower court. Some of the dicta that Judge Porcher used was less than perfect, but the issue before this court is, has the state procedural law been satisfied, particularly Article 53, and we submit that it is not. Are there questions?
I think we've got it.
Thank you.
Thank you, and thank you for your patience of waiting to the very end today.